SJC-13117, Terence Meehan, v. Medical Information Technology, Inc.
Great. Attorney Mantell. Whenever you're ready.
Thank you. May it please the court. My client, Terry Meehan, was fired because he exercised his legally guaranteed right to file a rebuttal to a performance improvement plan.
Counsel, can I ask you a question about this for a minute, just before you go further, right here? And that is, you say he was fired for exercising his right to file the rebuttal. Is that how it was expressed to him, that it was because of filing the rebuttal, or is it because of the content?
No, we have actually direct evidence that it was the filing of the rebuttal. There is an attachment to the complaint that says Mr. Meehan has filed this rebuttal this morning. They immediately scheduled a meeting at 11:30 that morning to discuss the rebuttal. And at that meeting, the president and CEO says, we have to terminate him.
Because of the rebuttal?
Yes.
Okay.
I mean,
Not because of the fact of the rebuttal.
they indicated no basis in the content of the rebuttal as the basis for the termination.
Counsel, can I ask you, is this a binary issue, in that if there's a statutory right granted by the legislature, then it is by definition or operation of law protected by the public policy exception?
It is, and the analysis ends if it is an employment right.
Right. No,
exercised by
I'm
an employee.
assuming it's employment right.
Yes.
There's no importance under your view of that right.
That's correct. And I think that's established by both Mello and your decision in King versus Driscoll.
Right. So, and just one last question. So, for example, if we had a habitually late employee situation, and the late employee, and they were being disciplined for tardiness, and the employee said, you know, I overslept because I thought my phone was charging, and you know, that's why I overslept, and they're fired. Is that actionable?
No, that is not actionable.
Because and they said, you know, that's no reason, and they said, well, you fired me because of, you know, because of my rebuttal to my performance plan or to the reprimand.
In that case, it would be a issue of fact as to whether the person was fired because they were late or because they filed the rebuttal.
Right, but you get over a motion to dismiss, correct?
That's correct.
Right, so do you see where the exception of public policy could swallow the at-will rule, if that's the law?
No, Your Honor, because this case falls cleanly within the Smith-Pfeffer categories of public policy. Everyone already understood that conduct such as this would be protected. And moreover, employees such as Mr. Meehan are already in 7 to 12 protected categories already. So just because you're in a protected category does not mean that there is an invasion into the at-will rubric.
I'm sorry, I'm not following you. What do you mean by protected category?
So for example, under the discrimination statute, just the most passive employee, they're protected because they have a race.
Right.
They have a national origin, they have a religion, they have a gender. Everyone is constantly in protected categories. Okay, so just because Mr. Meehan is in a protected category does not change the nature of at-will rule. The courts have said over and over, including in King versus Driscoll, that the Smith-Pfeffer categories are consistent with a vibrant at-will rule.
Do you think the appeals court got it wrong by an importance component, the catch-all to this statutory component?
I do, Your Honor. First, as you said, if we're talking about an employee right exercised by a person in their status of employee, the analysis should end. But even so, these issues are important for at least 4 reasons. They're important to the employee because their career is on the line and because they have a right, an interest in making sure that they're not retaliated against because they exercise a right. It's important to the employer because under the rebuttal rubric, they have good, true, and accurate records to make decisions, and they can't be led astray by a rogue supervisor. Society as a whole benefits because the documents generated can be sent to third parties such as a court, such as the Attorney General, such as the MCAD, the Mass Commission Against Discrimination, in order to enforce our most fundamental laws. So it's important for that reason. We have 3.5 million employees in
I get,
Massachusetts.
are you done?
I'm
sir?
done. Yes.
Can so the employees, but let me give you a hypothetical. I'm not saying this is your person, but the employee is a hothead. He doesn't take criticism well. That's the basis of the evaluation, you know. Anytime we give you any criticism, you lose it, you say we're wrong. And then he writes back in his rebuttal to the personnel file, you're a bunch of idiots. I'm doing a great job. What do they do then?
If the content of the rebuttal
Right.
establishes an independent basis for removal, the employer is free to act on that independent basis.
So in my example, where he's just confirming their views of why he's a lousy employee, can they terminate him based on the information in the response or not?
Well, again, there's a question of fact. So for example, did he say the same thing the day before? And did other employees say the same thing out on the floor?
They don't need something that the personnel file can be the additional new thing to terminate him, or do they need something after that to terminate?
No, if you do something threatening or inappropriate,
I'm not saying threatening. You're confirming the problem. You just don't learn. You don't listen, you don't learn. And your response confirms that. Are they free to terminate you, or is that a violation of public policy if they terminate you for that?
they are free to terminate.
Mhm.
There is, if it would be an independent basis for termination ordinarily. So for example, if he had made that statement the day before or in a different communication and the employer said, oh,
No,
this just
I'm saying he does it in the response. He says something in the response that confirms their views that he's just not getting it. But you say they can fire him for that. And I'm not sure what it is they can't fire him for. They can't fire him just for the fact that he files a rebuttal. That's all that this case is about.
Well, when you file a rebuttal, what you're doing is you're saying to the employer, you're wrong. You're standing up for yourself. You're showing how they're not being fair.
I
Okay,
totally get it. I understand why that's important.
and that's protected.
But you're saying it's not in a certain, I mean, back to Justice Cypher's original question, is it about the substance of the response or just the response? Because employers, I mean, only the stupidest employer is going to fire you because you responded. But somebody may fire you because you responded inappropriately, confirming that you're not a good employee. But are you allowing that distinction, or are you collapsing that distinction?
Let me answer this way. What's being protected here is the process and not particular documents. And let me back up a bit. Smith-Pfeffer says that the prototypical claim is someone fired because they filed a workers' comp claim. Okay, so in that situation, you do not look at the actual injury. You don't say, oh, is it a minor or major claim? And you don't even look to see whether the claim will be successful or not. It's the communication from the employee to the employer that's protected, the process. So just as the employee can't be retaliated against, other employees see, hey, I can file workers' comp claims and I don't, and I'm not going to be retaliated against. So just because the rebuttal may be factually inaccurate or whatever,
Can I
that
ask
doesn't
you-
mean that it's not protected. But if
I
it,
should know the answer to this, but say they discover that it's a complete lie, that he's not hurt. Can they fire the employee in a workers' compensation case for that? So he filed the workers' comp claim, but it's a lie. Can they fire you for that?
I don't do workers' comp law, so I don't know the answer to that.
And can I ask one other question about this? Is,
That seems like a fraudulent filing to me, just standing up here, but.
so the remedy, I guess then the other question I've got is, the legislature could have gone one step further and said, when you get fired right after for this, you can't be fired for this. They didn't write that into the statute. What do we do about that? Is the remedy limited to correcting the personnel file so that when you get terminated, you have a full file to look at, or is the remedy include this additional step?
Public policy remedy only takes place when the statute fails to identify a remedy for retaliation. So
But here
we're
we
right in the
do-
wheelhouse.
Here we do have a remedy for being mistreated in the personnel world. You get a remedy in the sense that you get to put in your personnel file your response. That is somewhat of a remedy. It may not be a great remedy, but that is a remedy. I mean, that's so that when you file your discrimination claim, you're in that protected category. Then they have the whole personnel file that says what the employer said and also what you said. So here, there is somewhat of a remedy, isn't there?
No, there's no damages, for example. There's no front pay, back pay, emotional distress, things like that, things that normally attend.
There's an attorney general liability though, right?
There is no attorney general liability for a retaliatory termination. There
No,
is a fine
Right,
if they don't maintain the file properly.
right. But
And
so
so
what the dissent said in the appeals court, is failure to recognize would render the statute illusory, correct?
that's correct.
What about the attorney general component of this in the fines?
Well, the fines are criminal in nature, and there's the rule of lenity, meaning if it's a criminal statute, it's not going to be broadened beyond the words of the statute, which means that public policy has to step in when the statute does not provide a remedy. And here, as the dissent says, we have a public policy worth defending. It would be, the dissent says, only a fool would exercise their rights under the statute, because basically the appeals court gave employers a roadmap for incentivizing bad records and firing people who speak out.
But isn't that an overstatement? I mean, most employers and employees are not engaged in a game of firing. They're engaged in a game of improving employee, they want a better workforce. So, I mean, the employer is doing an evaluation not to prepare to fire most people, but to make them better employees. It's hard to get good employees. So
So-
people are going to use this process no matter what. It's not just a game to get who gets to fire whom.
It's already happening, Your Honor. There was an article which the Mila brief quoted, which says, employees should use caution when submitting a rebuttal to their personnel file, should they decide it is wise to submit one at all. Now, the bone-chilling
Who
part
wrote-
of that
who-
statement,
Who wrote that article?
a defense counselor. So that's the eerie part here. That's what the defense counsel is saying. You don't want to do this necessarily. And of course, the Mila brief in their statement of interest certified that they're already advising clients to use caution and that maybe they don't want to use the rebuttal process either. This is a primary way for whistleblowers to make their concerns heard. This is a primary way for agencies to discover pattern and practice violations and misconduct. And it's being chilled And so I disagree with you that it would be rare that employers would do
May I
this.
ask you a question about the chilling factor and enforcement? It says in the statute that the Attorney General enforces this, right?
Correct.
So how does your client have the ability to enforce it?
The client is not enforcing the statute. The statute does not cover retaliatory discharges. That's why the public policy tort steps in.
So
to
it doesn't
preserve-
cover it all. You're saying that doesn't apply, that part of it?
It only applies to show that the legislature thought that the Public Records Act was important,
I see.
that they increased the fines, and yes, that they put the Attorney General in charge of it. But they did not foresee that employers would be so petty that they would fire someone for speaking out in this way. So when that happens, the common law.
Well,
steps in.
why would they put that in? I mean, oh, never mind. Go ahead. Keep going.
Oh, okay.
Mr. Minto, before you sit down, when we hear from the appellees, they're going to talk about the issue with King versus Driscoll. And the Attorney General points out that the majority and the dissent have this disagreement about what the case means. And of course, the amicus brief from the AG talks about what you're talking about, that the statute is actually the right to file this rebuttal actually protects an employee in his or her capacity as an employee, and that you don't need a public policy reason. You don't need an important reason. So before we hear from the appellee, where did the majority in the appeals court, in your view, go wrong specifically in analyzing the King case?
There's a very specific part.
I understand. That's what I want you to talk about, please.
Yes. So King says the employee did not engage in an important act because the act of filing a derivative suit is A, not important, and B, internal to the employer's internal functions. And then King says, but this would be different if employee rights were at issue, indicating that the importance and internality are not factors if employee rights are at issue. So what the appeals court did is they used the King analysis, kicking the case out, but then indicating the King principle is applicable in cases involving employee rights, which is absolutely opposite of what King itself says. So that's the main problem. As I run out of time, my co-counsel James Kobe and I ask you to recognize a public policy protecting people doing exactly what the legislature wanted them to do.
Okay, thank you very much. Attorney Brewerton, excuse me.
Thank you, Your Honor. Madam Chief Justice, may it please the court. My name is Scott Brewerton and I represent Medical Information Technology, Inc., which does business as Meditech. Your Honors, this court has consistently construed the public policy exception in a very narrow manner so as to prevent the general at-will rule from being converted
Just so
into.
I'm sorry, just before you, are we all in agreement that the employee was fired simply for filing a rebuttal?
I am not in agreement. It strains credulity to believe that an employee is fired simply for submitting a rebuttal.
We're at the motion to dismiss phase.
We are, and with that said, as a matter of law, an employer should still have the ability to discharge an employee, even if it only is.
Why
for some-
isn't this a binary issue? The legislature has said for employee rights, the right of rebuttal, correct?
They've given a mechanism.
They're given a mechanism for rebuttal. So the legislature has told the world and the state that it's an important employee right, or it's an employee right, whether it's important or not, you'll talk about. In our case law, when we go through the categories of public policy exceptions, talks of statutory rights, things that are codified. Why isn't binary in that instance that we shouldn't recognize it?
So it goes to the narrowness of this exception, Your Honor. I would contend that the right still must be important and well-defined for the public policy exception to apply.
But it seems like you're conflating all the four categories to get there. Address the first one,
So,
find right, as embodied by codified law.
so I would contend that the two-step process, to the extent that there is one, ask, does the public policy first fall into any one of these four categories? If the answer to that question is no, we're squarely outside of this public policy exception. If the answer to any one of them is yes or maybe, then the second step should be asking, is whatever the public policy was invoked, is it important enough and well enough defined to state a claim under what should be a very narrow and very limited exception?
And I may be completely off, but I thought that was the fourth category, the catch-all.
So that's what the plaintiff and some amici contend. I would disagree with that evaluation. I would contend that the importance and well-defined criteria are necessary for each category.
You think that's an overlay
Yes,
of every category?
correct.
But how can we really say the legislature thought this was important enough to create this statutory right? They're basically telling all employers in the states, you have to provide a right to rebuttal. That seems to be, I mean, we seem to have moved beyond importance there. The legislature thought it was important enough to interfere with every employment, every company of a certain size in the state, saying your HR department has to give you a chance to respond. Aren't we beyond importance at that point? I mean, it's important enough for the legislature to define it. I mean, I don't even if we accepted yours, I think you lose on that point.
Well, I would also keep in mind, Your Honor, that this court has held repeatedly that the internal administration matters policy and functioning of an employer cannot form the basis of the public policy exception. And if an employee can state a claim simply under Section 52C, it actually has the potential to wipe out the entire.
I'm worried about what this means if we go beyond. I mean, allowing a rebuttal seems fine. The question to me is the substance of it. But you're saying we don't, in this case, have the substance in any way before us. All we're dealing with is this narrow issue of an employer who has this automatic reaction and fires someone for exercising a statutory right.
So I would also point out, Your Honor, that the plaintiff did not allege that the rebuttal didn't go into his personnel file or that Meditech violated the statute in any way. This would be one of the rare situations where an employer complies with the letter of the law and yet is still getting sued. And what would effectively happen is our courts would become super personnel
I think the
departments.
legislature contemplated the possibility. We've created a statutory right to file a rebuttal to keep the integrity of the personnel file, meaning that everyone has an expression here, because personnel files end up in all these lawsuits, separate from this kind of silly lawsuit, but they end up in discrimination suits and all kinds of other things. You think that the legislature thought it was okay to require this, but then to fire someone for exercising that right?
I think that they very well could have and likely did. So they could have put an anti-retaliation provision in the statute. Instead, they said an employee shall have a remedy through judicial process to have records, false or erroneous records, expunged. If they had wanted to include an anti-retaliation provision, the legislature is very well equipped to add an anti-retaliation provision in the statute. And furthermore, in 2004 in Kessler, the appeals court held that an employee cannot seek legal damages under Section 52C. And the legislature implicitly ratified that decision when it amended the statute subsequently in 2010 without adding any type of provision to the statute allowing an employee to seek legal damages.
Yeah, but it provides the jumping off point for lawsuits afterwards. It can provide the basis for a discrimination suit. It can provide a basis for some kind of workplace tort suit, right? It creates a vehicle to provide for lawsuits. And the personnel file becomes sort of the fighting, the issue you're fighting about, because it's the documentation of the employee and the employer relationship.
And in those circumstances, the claim that an employee would be bringing is under those substantive employment statutes. It's a discrimination claim, wage and hour claim, FMLA claim. This is a wholly separate category.
But one of the ways you evaluate whether someone's been discriminated against is, are the reasons true or not? And if they're not, you start looking at whether they're pretext for something else, right?
And if they're not true, an employee already has a remedy through judicial process to have that information expunged from their record. That's a precise remedy, in addition to including the rebuttals in the file that the statute allows for. So if the employer is making things up and adding things that are factually inaccurate to the file, an employee can go to court and have that information removed.
So counsel, is that the only bomb then for the purpose of this statute? Because what I'm struggling with is you're saying that the legislature gave a fired or employee that disagreed with the bases the right to rebut or right to give some context to why they think that the employer got it wrong. And that's it.
That's it. That is the end of what the statute allows. And I understand that might not be satisfying to the plaintiff, but that's as far as the legislature determined to go.
So why would that make sense?
That would make sense because keep in mind, rebuttals are only submitted when an employer and employee are at odds with one another. So for an employer to be able to have the broad flexibility that it needs to run its business as it sees fit, even if an employee is, just submitting rebuttal after rebuttal after rebuttal, disagreeing with their employer's lawful business judgment, there comes a point where an employer can say, this employee is not going to improve the way that we're trying to help them improve. They're not taking the steps and the constructive criticism that we're providing to them. All that's taking place is every time we write a performance memo, performance improvement plan, document misconduct, it goes back to the example that Justice Kafker was brought up, that the employee just constantly is unwilling to accept that criticism. And in that type of situation, an employer should have the ability to discharge an employee.
Not sure why this statute says that the employer wouldn't, though. And you can help me, but I'm having a hard time seeing the sky is falling down argument that this is going to get us all involved in the inner workings of private companies and the Pioneer Institute's concerns about the economy, because all that is protected here is the right to file a rebuttal. If the reason for discharging somebody exists separate and distinct from the filing of the rebuttal, by way of example, that the person's just not getting it, refuses to learn. All of those issues are reasons that an at-will employee can be discharged. It's just if the plaintiff is able to demonstrate that they were discharged just for exercising their right to file a rebuttal under the Personal Records Act. That's the limitation of the right.
And I think that there could be causation issues there, though, Your Honor. And what would ultimately end up happening is our courts would end up becoming super personnel departments. Was the employee fired simply because they submitted a rebuttal? And if that right, if that is recognized under the public policy exception, what will inevitably end up happening is any employee who thinks they're close to termination will submit a rebuttal, know that they have a lawsuit in their back pocket when they ultimately are terminated for some type of at-will reason, or maybe even for cause. The employee will then be able to say, at least I've got one count. I can walk into court, sue my former employer, bog the courts down in litigation, or potentially extract a
We don't
settlement.
interpret statutes because we think there's some people who are going to act for the most unfortunate of reasons. I'll use as innocuous a term as I can. For that to happen, somebody needs to be able to be willing to go through the expense, the emotional investment of filing a fraudulent lawsuit. I mean, I just don't think we interpret the statute based on the worst possible behavior we can contemplate of people.
Understood, Your Honor. And that's why I think it's important to keep in mind the narrowness of the public policy exception. This exception is supposed to be, applied in rare circumstances. I believe in one of the cases, the court notes that it's exceedingly rare that the courts have recognized the type of statutory right that allows an employee to invoke the public policy exception. And I would contend that a procedural record keeping statute like Section 52C is not the type of statute that we should be broadly expanding this narrow exception with.
I'm confused about, so if you say if we draw a distinction between firing for just filing the rebuttal versus getting the substance, we're going to become a super HR department. Why is that? Because I'd like to understand that, because are you saying then that we're going to get into a fight about whether something was for substance versus rebuttal each time? Is that what your argument is?
Precisely, Your Honor, precisely. And in many of these cases, the employee will be rebutting an employer's lawful business decision.
But isn't the court's binary, using Justice Gaziano's terminology for a second, wouldn't it be, okay, it's simply this: did you fire because of the substance of it, or did you fire because of the rebuttal? If you fired because of the substance, we're still an at-will employment issue. If you filed just for the rebuttal itself, that's different. So what is that? So that's not really becoming an HR policy. We're just enforcing the statutory distinction.
But I think it will pull our courts into these situations of trying to determine, was the employee fired because they were complaining about internal matters, which in Wright, Smith-Pfeiffer, Upton, et cetera, this court said does not rise to the level.
But then aren't you playing into the view that the dissent articulated, which is then it's just a pointless endeavor and a dangerous one too, because that's, if we don't draw this substance process distinction, what's the purpose of this?
I don't think that it's pointless, because if there were a substantive employment claim, like a discrimination claim, an FMLA claim, that were predicated on what's in the personnel record statute and the rebuttals contain, or that's in the personnel record itself, and the rebuttals contained in there, so long as the employer is complying with the statute and adding those rebuttals to the personnel file, the statute is operating as it's intended.
Okay, everybody all set? Thank you so much.
Thank you, Your Honor.